Welcome. Uh, this presentation is to deal with legal maxims and is brought to you by Denied Truth. Legal disclaimer. The information provided in this presentation does not constitute legal advice, and the web hosters as well as the author cannot be held responsible for your action or inaction and does not warrant any sort of understanding or take responsibility for your understanding of the contents provided herein. It is strongly suggested that the viewer take the initiative to do the research to understand and use this information in the appropriate fashion. Given the fact that the author and web hosters are not responsible and do not draft your documents, we cannot be held liable for how you use or misuse this information. This information presented is accurate at the time of this presentation, but there's no guarantee that this information doesn't change slightly and that this information is 100% error-free. You as the viewer are 100% responsible for ensuring that this information is used correctly and matches your specific situation. With the legal disclaimer out of the way, we can now proceed. What is a legal maxim? A legal maxim is an established principle or proportion of law, and a species of law basically that has been argued over time and is well established now in case law. And you can make reference to these legal maxims and the presiding case when you make any legal argument that operates under English law. So this would be applicable to people in the UK, people in Canada, people in the United States of America, and any other country that uses English law. I have provided a PDF file, which actually is the list or the source of these legal maxims. And there are many legal maxims listed within that document. It is highly suggested that you download that document and have it on hand for review as we go through this presentation. If you look at this screenshot, you will see that there is a number of columns. The legal maxim, which is usually written in Latin. I've disregarded that because most of us are not dealing with Latin. Then I transfer it to the literal meaning, and I give you an interpretation underneath on the following slides. And I also give you the judicial pronouncement, which means the case law. And then within the case law, you'll notice the following, the last paragraph, it actually tells you what section of the case law that this is quoted from. However, when I did my presentation, in order not to overfill or cram the screen, I left out the information in the last column. You can extract that information from the PDF if you wish to use a particular argument within your case. I have covered basically the second, the third, and the fourth column in this presentation, and I've pulled out what I feel is the relevant information pertaining to most cases that you should ever have to deal with. A court action could be heavy is the first legal maxim. According to this maxim, any undeserved or unfair advantage that has been gained by a party invoking the judicial court, the same requires to be neutralized. In other words, no man should suffer because of the fault of the court or delay in procedure. It is not only within the power, but the duty as well of the court to correct its own mistake, in order to see that no party is prejudiced by mistake of the court. Therefore, if a court is making a mistake, you have the right to ask that court to correct its mistake, provided that you can clearly demonstrate it. This is usually done either in a written letter or within an affidavit. Most court cases require an affidavit to be filed. Done without indicating the inner secrets. Overt acts make known latent thoughts or acts indicating by the intention. Okay? This basically states that if somebody is intending to hide information from the court, and you are presumed to have that intent, and there's a natural consequence for your actions. This is particularly applicable when an officer of the court or a legal representative, if it's in the UK, legal advisor, withholds information in a court hearing that is either prejudice to himself or prejudice to you. Generally, it's prejudice to himself, and does not advise the magistrate's court. There are a number of infractions that deal with this type of information, specifically dealing with council tax. However, these type of situations are not limited to council tax. It happens in all forms of court. And the reasons for that should be self-evident in that there's a conflict of interest. If the magistrate's court operated correctly, or if a regular court operated correctly, and a legal advisor was there to fulfill their position, and they fail to do so, it would affect their paycheck, right? Conflict of interest. No one except before God. This legal maxim denotes any accused person is entitled to make a plea of not guilty, and also that a witness is not obligated to give a response or submit documents that will incriminate himself or herself. Not only does this law refuse to call on a man to accuse himself, but will also not admit his confession unless it is shown to have been made freely and voluntarily, and I give you the case law. Basically, what this is one of the amendment rights under the U.S. Constitution, and the right to not self-incriminate. And that's a well-established law. No provision of the law shall depart from the words within the law. There must be no departure. This basically says if you read a statute, or a law, if you will, the interpretation of the statute determines the intention of the legislature. So they're not really allowed to go through and pick and choose which sentences they like to use and which ones they don't want to use based on their own interpretation or their own opinion. The law is generally to be considered in its most broad form. However, if the law is clear that certain things are permitted or certain things are not permitted, it's not up to a judge or a legal advisor or a legal representative or a self-litigant to simply pick and choose. The object is to determine by the intention of the legislature conveyed expressly or implied in the language used. And I've given you the court case. Intention to harm. It is the state of mind of the accused related to the person's knowledge of facts that he is committing a crime. Well, that basically states that if a person intends to harm, they can be held liable. It goes on to say that a person knows the law and forbids the action, appreciates what the outcome of the action will be, and specifically intends to break the law. It is generally absent in mentally ill and minors. Well, that makes sense because a mentally ill person may not know or understand the full context of what they are doing. However, when we deal with a court case, the justice of the peace or the magistrate or the judge or the prosecutor or even the self-litigant, if they intend to break the law and they do so, they can be held liable, and I've given you the court case. The intent has to be there. Earlier in time, stronger in law. He who is first in time is stronger in a claim, a legal principle that the older law takes precedence over the newer one. Meaning that if you find an old case law which has arguments in it that speak to the same type of arguments that you're dealing with in your particular court case, you can reference that case and reference the subsection of that case, which specifically backs up what you're trying to argue. I will advise the reader that a lower court is obligated to follow a higher court. We get into that later in this presentation. Prima facie evidence means evidence on its face of it. A matter that appears to be significantly based in evidence or considered to be true lends itself well to any other statement you may make that is more than likely also true. The opposite is also true, that if a person is knowingly to commit perjury, which is telling a lie, or misrepresenting or misguiding the court, then more than likely, prima facie evidence on the face of it, if they lie once, they will probably lie again. Therefore, when you bring any information into a court, either written by way of an affidavit or a statement, or orally, you're best to have all your facts true and verifiable. Through lack of care, the rule basically says here, if a court omits to consider a binding precedent of the same court or a higher court, a superior court, rendered on the same issue, where the court omits to consider any statute or law, if you will, while deciding the issue, it's basically through lack of care, and you have now legal grounds to have that case dismissed. This is quite common. When a person deals with local municipalities or local courts, very often the court omits to consider a binding precedent case and or refuses to look at or review the statute, and very often selects only specific sentences within the statute instead of considering the whole statute as it was intended. And we've covered that previously. So it's through lack of care can be one of your grounds for having the case overturned or dismissed or reopened, called trial de novo. Each case is specific, each case is different, and there may be grounds where you can use this, there may be grounds when you cannot use this. The standing of the decided do not disturb the claim. The legal doctrine basically obligates the court to follow historical cases, as I've said earlier, when ruling on a similar case. It ensures that cases will basically be handled the same way. This generates or creates consistency within the legal arguments. Therefore, when you bring a case into court, you are best to understand your case inside out, be able to quote it and be able to defend it. The last thing that the court needs, and the last thing that self-litigants need, is somebody going into court and setting a precedent based on false information or incorrect information, which therefore will bind lower courts to follow the same procedure. This is quite common with self-litigants. There is a particular case that comes out of Alberta's Queen's Bench when a self-litigant tries to argue their rights related to the Constitution or to a statute called Meads versus Meads. And many times they label a self-litigant an opto-pseudo-litigant, which in essence is defamation of the person, as that may or may not even be their intent. I highly suggest a self-litigant look up the Alberta court case, Meads versus Meads, and please do not make the mistake of making the same arguments that were presented in that case. There are a number of arguments which are beneficial, but there are a number of arguments which are not beneficial. Instead of calling these people opto-pseudo-litigants, they also sometimes refer to them as free men on the land. And there was a number of people in the past which did operate on this free men on the land thing, which now set the precedent, which we don't want to have happen again, and screwed it up for the rest of us. The reason for the decision. This is a common thing with most court cases, in fact all court cases if they're conducted lawfully, that you have a reason provided by the court for the decision that they made. To just say you're guilty or just, make some legal prediction or legal announcement without justifying their own rational thinking is not permitted, and I've provided the case law. If you notice, most of these cases that I bring you they're listed as SC, which means Supreme Court or Superior Court, or it may also have DC, which is Divisional Court, which is an appeals court. So all the decisions that I've been presenting so far, and the ones that I will present in the future, are all from a higher form of court, at least for the most part. At the person is another argument. This thing is basically used to misguide the court. And in this case, I left an example. Okay? It's used to counter an argument. It's based on the feelings of the prejudice rather than the facts, the reasons, and the logic. It is often a personal attack on someone's character, motive, rather than an attempt to address the actual issue at hand. And I've given you the court case. Now, as I said earlier in the presentation, you sometimes have to, in fact, you should always, quote what section of the case backs up your claim. So in this case, I left the example at point 22, the power of the judiciary basically goes through, and the construction stood not to be usurp or infringe the executive or legislature. Secondly, the Criminal Law Special Provisions Act, number 1, 1962, as well as the Criminal Law Act, number 31 of 1962, were aimed at individuals concerned with basically legislation affecting criminal law of general application, although not in every enactment. This ex post facto necessarily infringes the judicial power, yet there was no such infringement in the present case by the above two acts. Now, you're going to say, what's all this mumbo jumbo? You know, what the heck does it really mean? And unfortunately, it's up to you to be able to argue it. But what they're saying here is the attack of the person has nothing to do with the two acts or statutes which were presented. That's what at the person means. So it's a collateral attack on the person rather than addressing the legal binding arguments presented within whatever statute. Damage without legal injury. Now this is important. Damage in the sense of money, loss of comfort, or services, health, etc., without infringement on a legal right. Injury to a legal right refers to an injury which is being suffered by the plaintiff generally, but there's no violation of any legal right of the person. It is not an actionable in law event if the act did so was intentional, was done to cause injury to another, but without infringing a legal right of the person. Well, this goes back to our initial presentation, where you do have the legal right of the person under various primary and secondary legislation. So to transpose this into something that makes more sense, basically you can have a damage without a legal injury if they're infringing on your rights. This happens quite often, especially when an individual, self-litigant, goes up against the local municipality or against council tax or against the income tax or HMRC. So when a self-litigant goes into court, very often they try to misconstrue or misguide the court, which is an attack, and it's in a sense of money because they're seeking money. It's also not comfortable because you're being under threat and duress. Okay, and it's also maybe detrimental to your health. So there's specific provisions where you may be able to use this argument if you're being attacked in a court case, either on paper, which is called a pleadings portion, or actually on the floor of the court, which is your oral presentation. We will get more into this with a secondary seminar, which deals specifically with court and how to deal with court, how to file paperwork in court, and some of the things to watch out for. An act does not make a man guilty unless there is a guilty intention. Now this is also very important because the act doesn't make the defendant, because that's usually you, guilty without a guilty mind. In other words, the act itself does not constitute guilt unless it was done with guilty intent. To put it another way, if you did not intend to break the so-called law, then you cannot be held guilty of breaking the law. If you read a statute or you believe you're acting lawfully and you're not doing any harm to any other individual, then you are perfectly within your right. Now, many people will have reasons why they don't wish to pay their property tax, or they don't feel the bill provided by some service provider is correct, or they don't believe in, the actions of the local municipality are fair or just, or in fact that the municipality or the company that they're addressing is breaking the law. You have a right then to do a formal request or do a letter, and you have a right to withhold payment. Now, is withhold payment breaching a contract? Potentially, yes. But if the potential contract or the implied contract is in fact with a company or an individual or a government agency which you believe is acting unlawfully, you have now established what is called lawful excuse to withhold the payment pending the outcome of a hearing. So you're not really guilty. In fact, you are attempting to uphold the law. Now, many people may use this if they find a company a misappropriation of funds. If they're spending funds which does not basically agree with or confer their legal authority to do so. We can get more into that with specific cases. But as long as you don't have the criminal intent to break the law and you believe you're acting lawfully, you can use this defense. Guilty act, the act that proves criminal liability. Now, this is very important because the court officials or the government or the local law enforcement or, in fact, the court itself should know the law. There's another maxim which is not within this presentation that says ignorance of the law is no excuse. Okay? So if it's your job to know the law and the limits to which you can act, then if you knowingly break the law, it's a guilty act and you can be held criminally liable. This can be used against a court official, against a police officer, against a school or a school staff, against a company, or against the local municipality, if in fact they are breaking the law. Fraud and just never dwell together. Fraud corrupts justice regardless of the good faith or just intentions. Put another way, fraud destroys all that it touches. So if a contract is based in fraud, if a court operates unlawfully and commits an act, or in some cases several acts of fraud, or if the legal counsel commits an act of fraud, then you have grounds to have that case dismissed with prejudice. And with prejudice simply means that that will be on record so that they can't do this again. And we will get into with prejudice and without prejudice in a separate seminar that deals specifically with legal matters. Law, or right, does not arise from injustice. So, if a court breaks the law, or if a prosecutor breaks the law and does something unlawfully, or fails to do something which therefore makes it unlawful, when the fact arises from a legal or unlawful act or omission, it cannot form the basis of a law or a legal right. Therefore, if a lawyer or a court breaks the law in any court case that you're dealing with, and you can prove it by some way, shape, or form, that therefore makes it injustice. It makes the court case fraud. It makes the conduct of the court fraud. Now that is known as fraud on the court. So if you want to do some research, look up fraud on the court, and you will find that if a court operates in fraud, it loses what is called subject matter jurisdiction permanently, meaning they can't bring you back into that same court for the same crime, or in fact for any crime. And the reason you can assert this is because the alleged crime happens to a subject, and that subject is you. So if you've been prejudiced or somehow done wrong by a court, there is now what is called a conflict of interest against you, because probably you're self-litigant, and or because the judge doesn't like self-litigants, or maybe doesn't like your conduct or your demeanor or the way you dress or the color of your shoes. Who cares? The point being that if a court operates incorrectly or incorrectly, and there's an injustice, that is a grounds for dismissal. Now, if a judge or a legal advisor in a court fails to allow you to present your case, fails to allow you to give all of your oral arguments, fails to allow you to cross-examine, fails to allow you to make a closing statement, fails to allow you to address your paperwork or address the paperwork which has been provided in some way, shape, or form, then that's an injustice. And that does not permit them to proceed. And I've given you the court case. Again, this is from a higher court. There is no wrong without a remedy, or where there is a legal right, there is a remedy. Meaning, if you've been done wrong by the court, or by a company, or an individual, you have a remedy. Okay? Now, based on what that wrong was, there's a thing called the statute of limitations. So generally speaking, you have roughly 2 years to bring a claim before the court. There are certain exceptions to that rule. Those exceptions would be when there's a wrongdoing, like a fraudulent wrongdoing, a criminal case, such as, you've uncovered the fact that a company is embezzling money, or you've uncovered a murder, you've uncovered a rape victim case, then there is no statute of limitations. So be very careful before you bring a claim into court to make sure that you have the right to do so and that you have done it within the right time frame. We will get into that later in a separate seminar. No man can take advantage of his own wrong. This affirms what we said in the earlier slide. A party may not derive an advantage from its own unlawful acts. So if a court or a court clerk or judge or the person that's coming against you does the wrong, whether you're the plaintiff or the claimant, as we may call it, or whether you're the defendant or the respondent, which is the person defending their position, defending their rights, if there's a wrong on either side, then that person can't take an advantage of the wrong. A foundation being removed, the superstructure fails. This again affirms what we've said in the last 2 slides. If the initial action is not in conformity with the law, all subsequent and consequential proceedings fall through for the reason that the legality strikes out the root of the entire event. To put it bluntly, if the case was flawed for whatever reason, then everything that happened with that case, including a conviction, is also wrong. And again, this is from a higher court. And this is precedent case law going back to 2007, if we look at the documents. Legal maxim, he who asserts must prove. This is a really big one, because whether you're the plaintiff, meaning the person making the claim, or the claimant as we call it, or whether you're the defendant, person defending the claim, sometimes referred to as the respondent, if you assert something in a court case, you must provide the proof. And I often tell people that the proof is in the paperwork, right? So if you can bring in, by way of an affidavit, generally, a document which has photographs or other documents which are signed, or if you can bring in a witness, okay, That is all ways to assert your claim. You cannot go into a court and just say, well, I believe this or I believe that. As an example, if I walked into court and I said, well, Santa Claus is real. I mean, I can see it on television, right? And there's only one Santa Claus. So the first thing the other side's going to do is they're going to say, okay, here's 3 or 4 pictures of Santa Claus and they're all different. So now that's not one and the same. I've just committed perjury. Once I commit perjury, which is basically telling a lie in court, then my entire case and myself become non-credible, and the case goes out the window. Therefore, under this legal maxim, he who asserts must prove, be very clear that when you quote a law or you try to assert a claim, you provide the necessary proof by way of documents, photographs, witness testimony, even if you have to like prove destruction of property, bring in a piece of the destruction of property, the thing that was smashed, into court, or bring in a copy of a void check, or bring in a bank statement, something like that. Okay, it says here, actor rests the burden of proof. The burden of proof lies on the plaintiff. So when somebody brings a claim, such as a council or local municipality, you can ask to have proof of the claim. This proof is supposed to be provided to you prior to going to court. That section of the proceeding is actually called pleadings. If they did not provide you any proof, or they did not contradict any of the statements which you made, and therefore they did not provide proof before you go into a hearing, they're not allowed to provide it after. This is particularly useful when we deal with council tax issues. Council will assert something, they haven't proven it, and generally the court will go along with it. So it could be used in that situation. There is no proof. What cannot be done directly cannot also be done indirectly, meaning that if there's no law to support somebody's actions in court, but they could do A, B, and C and then make up their own case based on this other activity, that's not right. It's not legal. Okay? It also questions the competency to enact a law when the legislature oversteps its conferred power. So if a court operates outside what it's legally allowed to do under the statute, its conferred power, as we will, then the case is void. Okay? So if the court doesn't have the authority, or if the contract doesn't permit, then it can't be done and say, well, see, now we did it, now it's legal. No. That's why it is very important for anyone going into court to review all the statutes which are relative to whatever court case they're dealing with. If it's in Canada, you would, and it was, say, a property standards issue, you would look at the Building Code Act. You would look at the Municipal Act. You would look at the Planning Act. You would look at the Land Titles Act. And you would see in those acts what sections were applicable to your case. Now, if you're in the UK and you wish to deal with, say, a council tax issue, you would look at the Local Government Finance Act. You would look at the Local Government Act. You would look at the council tax enforcement regulations. If you were dealing with something else, well, you would look up those specific statutes and see where they apply. Now, when we deal with stuff in court, there's also primary and secondary legislation. And what I've just outlined within this slide deals with secondary legislation. There's also primary legislation, and we will cover that in a separate separate webinar. Therefore, it is highly suggested that people stay tuned, and as we deal with specific issues, I will try to direct people to the most relevant legislation for their specific problem. This is why on the Telegram groups we have separated them into specific countries. One making a contradictory statement is not to be heard. Sometimes you will find a lawyer making a statement, or maybe a prosecutor making a statement today and it contradicts what they said earlier, or a defendant or a plaintiff may be doing the same thing. Make one statement now, a different statement later, and the story keeps changing. That is not permitted, and you can tell the judge that this is a contradiction of statements, and this principle works as an estoppel. What an estoppel really is that once this fact has been established, you're stopped, you're prevented from going any further. And again, we will get into this more when we deal with legal issues. Acting and consenting parties are liable to the same punishment. What this legal maxim basically states is a person aiding and abetting, so in other words, assisting the actual commission of a crime, or misleading the court, which actually is a crime, is just as guilty as the person that actually did it. So, if you go to court and you're dealing with the prosecutor on the other side, and he's breaking the law, and you advise the judge that he or she is breaking the law, and the judge goes along with it anyway, then the judge is just as guilty as the person, as the prosecutor was for committing that crime in the first place. This is particularly useful if you deal with the municipality and you say, hey, this is illegal, and they go along with it anyway. Then that case is void. That is fraud on the court. If the prosecutor brings something into court to mislead the court, and you turn around and advise the court of this attempted misleading of the court, and the court goes along with it, guess what? The judge and the court are both liable. And therefore, your case is fraud on the court, which makes your case basically disappear. It's void. The same thing can be said for council tax issues in the UK. If the local municipality, called council, turns around and brings in a case without establishing the facts, without allowing you to present your evidence or your oral arguments, refuses to look at anything, then they are complicit, meaning complying with, this unlawful activity, and therefore the case is void, and they're liable to the same criminal prosecution. If a person misguides the court, especially an officer of the court, meaning a judge, a lawyer, a clerk of the court, a prosecutor, then they are held to a higher standard. Because again, it's within their job description to know exactly what they're doing. And if they're knowingly breaking the law, misguiding the court, and you advise the judge, and the judge goes along with them, then guess what? Case is null and void. Equity follows the law. This is a concept, and equity follows the law will not aid a person or a party who is at fault. The law will not aid a person whose own fault is what made the legal action necessary. This is very important. So when you go to court, you generally try to resolve your issues with your adversary, okay, with the person that injured you, or whether it was intentional or not doesn't matter. If they refuse and they bring the matter into court anyway, and you've tried to do everything within your power, and say, let's say, for example, you're dealing with the municipality. I always stick to the same one so you guys can see how it relates. If you attempt to write to the municipality and say, look, you don't have the right to do this under this statute, this provision, here's some case law that backs it up, and this conduct that you've done so far is unlawful for the following reasons. And they say, we don't care, or they ignore you, and they bring your case directly into court. Okay? The law will not aid that person whose fault it is what made the legal action necessary. So if a person can't prove their claim outside of court and they haul you into court and then come after you saying, well, we're seeking damages against you for our court case, and there was no reason to have the court case because they didn't prove their claim, which is very common with municipalities and also with council tax, then it's not your responsibility to cover that expense. Okay? Equity, something of equitable value, And your time is equity. It's what we could call sweat equity. Money is equity. Okay? So if they're coming after you for something like that, some piece of equity, if we call it that, and there's no reason for it because they haven't proved their claim, you're not responsible for those costs. This is particularly a case when, like I say, municipalities do it, council tax officers do it. The justice do not answer to a question of fact. The jury do not answer to a question of law. This is important. Okay? The jury is the trier of facts. So when you present facts in a case, you're trying to convince a jury, okay, this to determine whether you're credible or not credible. When you bring something into before a judge, you present facts, but you also present law. And the judge's job is to interpret the law as it's written, not to put his or her own spin on it or disregard certain portions of it because it doesn't fit the narrative of fleecing you, the public, through the court system. So if you don't get a fair trial and you can show where the judge did not follow the statute, especially if you can announce it while it's being done on the floor of the court and they go along with it, that coincides with what we said earlier, and the case is not valid. This also means that if you go to a trial by jury, okay, which is a jury of your peers, it's not up to them to determine what the law is. It's up to the judge. However, if you do a trial by jury, you have a right to instruct the jury as to what the law states. You also have that same right in front of a judge. Remember that a judge's job is to be fair and impartial. So, basically speaking, assume the judge knows nothing of your case and knows nothing of the law. Be very careful to point out where you believe you're right based on the facts and where you believe you're right within the law. And then the judge has no alternative but to follow what you've presented, because the judge's job is not to render a verdict based on some law he or she may know unless you bring that law forward. That is very key, because a lot of people will go into court, especially as a self-litigant, and they will assume that the judge knows the law. Well, unfortunately, that's a bad way to go, because there's hundreds of laws, thousands of laws, in fact, and they change regularly. And I know ignorance of the law is no excuse, because it's part of his job. However, I don't also expect the judge to do the impossible. So it is your job as a self-litigant to make the judge aware of what laws and what rules that you're relying on. We get into this further in a secondary presentation that deals with law cases. Equity looks upon that as done which ought to have been done. So therefore, because all court cases in a civil matter deal with equity, they want money, equity, okay? The doctrine of satisfaction well illustrates the principle of law, where a person is under an obligation to perform an act, okay, which means follow the law. Equity looks on that as done, which should have been done, or should have actually been done. So if there's a mistake in law, you have a right or a recourse to correct it. This also means that equity, for the most part anyway, trumps all other court cases. So if you can prove where you have equity in a claim, and the other side can't prove anything, then theoretically you should win your case. Now, if we look at property, for example, let's say your place of residence, the place you live, you have put equity into that property. You have a mortgage, you do maintenance to the property, you do upkeep, you repair things as required, and basically keep the place in good standing. If some other individual comes to, say, try to take that property, they have not invested any time or any sweat equity or any funds. Therefore, you should win your claim. Okay? Equity trumps all. The act done by a means by me against my will is not my act. Basically, this states that if you are forced to do something against your will, it cannot be used against you later in law or later in a case. If you're forced to sign a document under threat and duress in order to be released from prison, for example, and you don't really want to sign that document, you can sign it under threat and duress. If they alter the document, that's criminal intent. So you now can put them in a really bad position. Or you can simply refuse to sign the document. In some cases, you may be forced to sign it in order to gain your freedom, which is again an unlawful act. And that deals with the rules regarding contract, which will be covered in a separate seminar. Right to the point. A personal right to a possession of property that usually arises from a contractual obligation, okay, such as a lease. Well, you also have the right to whatever piece of property you purchased, and you can prove that because you have a receipt, which means you applied equity. No one has the right to take your personal right or your personal property unless it's under some sort of a contractual agreement and they have put equity into that piece of property. So if you purchase, for example, a motorcycle and you tell your friend that I'll pay you back within 6 months or whatever, and you fail to do that, and maybe you also put equity into that contract, then they're entitled to half the proceeds. If they put 50% down and 50% was yours, they have rights to 50% of the proceeds of that motorcycle. They can force the sale of that motorcycle. Likewise, if they come along, say the municipality comes along and says, well, you have to dispose of that motorcycle. Sorry, no, that's my personal right of possession of property, and it's from a contractual agreement. You purchased it from the store or from a private individual. You put equity into it. They have no legal right to tell you you can't have it. Now, if you use it for unlawful actions, the police may seize it, but if you're operating lawfully and normally and not breaching anyone's peace, you have a right to possession of your property. This presentation was brought to you by Denied Truth and is only a brief overview of the various maxims in law which can be used. I know that there are well over 1,000 maxims, and you can look the various maxims up on the internet or preferably a law library, and please quote where you've got that maxim. You can then use that maxim as a reference when you draft court documents. I hope everyone found this information useful, and I hope it'll assist anyone in dealing with any legal matter, and not specifically with the ones I outlined, but any civil matter or any criminal matter follows legal maxims. However, you have to quote them and have to be able to argue those points. The ones that I've presented here are the ones that I feel would most commonly be used in all court cases. And you may not need them all, but you may be able to select 4 or 5 or 6 or 2 or 3 which best suit your particular argument. I specifically selected certain ones due to court misconduct or due to contractual agreements, given the fact that most times people who are self-litigants in a court who attempt to challenge the validity of the system, as we will call it, generally get labeled self-litigants, opto-pseudo-litigants, free men on the land, whatever, and they attempt to weasel their way through a court system which is not done in a fair and equitable manner. Given that fact, given the fact that most people are new or semi-new to legal proceedings, I selected the basic ones which I felt were applicable in most situations. I will be bringing further presentations forward that deal with specific legal matters, and I will go through specific points which can be reviewed by the viewer, and then the viewer should be able to follow and tailor the information I presented along with whatever their current situation is and hopefully get a verdict in their favor. I hope this information was useful, and I look forward to providing additional information in the future. Thank you for your time.